Today I'm going to speak to you about Article 15 of the Indian Constitution. Article 15 is one of the most important fundamental rights enshrined in the Constitution, and we trace this history way back to the nationalist movement from when there was an attempt to remove all kinds of discrimination based on religion, race, caste, sex, or place of birth. Article 15 is divided into 5 parts. 15.1 places an onus on the state to ensure that the state shall not discriminate against any citizen only on the basis of religion, race, caste, sex, place of birth, or any of them. It is important to note that this creates an obligation on the state, that is the government, to ensure social justice of and social justice of all the citizens. This article is restrictive in its nature when it comes to its applicability, whether it's citizens or all persons. Hence, since it is the obligation of the state, it is ensured that the state has the duty to make sure that a citizen is not discriminated against on the basis of religion, race, caste, sex, or place of birth. This seeks to bring about an end to the historic discrimination based on the caste system. Article 15.2 encompasses that no discrimination should be brought about even between individuals who are citizens of the country on the basis of religion, race, caste, sex, place of birth, and at the same time, it speaks about equality in access to public places, including restaurants, hotels, palaces, and common areas, which were initially prohibited during the caste system. The caste system in India has always discriminated based on profession and your origin by birth. That is why, through Article 15, subclause 1 and 2, there is a two-prong approach to ensure that not only are citizens protected by the state, and there is a responsibility on the state to ensure that social justice is carried out, economic welfare is carried out, because as we know, India is a welfare nation where the state, that is the government, is actually the parents' patrie. Therefore, there is the fundamental duty of the government to ensure the social, economic, as well as physical well-being of all its citizens. At the same time, only the state cannot be held to be responsible for ensuring equality in access. That is why the onus is also put on individuals to make sure that they are not discriminating. Because unless the mindset of an individual changes, the government cannot in isolation ensure that everyone is getting equal access to public places. Article 15.3 at the same time ensures that there is gender justice. The makers of the Constitution have recognized that since times immemorial, there has been gender disparity in India. And sometimes there is a need for positive affirmation to ensure that women and children are brought at par and equal opportunities are not always accessible to people, even though they are available to people. Therefore, sometimes to bring about equality and to bring about gender justice, it is essential that the government, through the legislation and executive actions, ensures that certain provisions, which in the form of special provisions, are made for women and children. Some such examples would be reservation for women, be it in the education sector, be it in the public services sector, that has been made specifically for women. Children are seen as the future of a country. India recognizes its human resource, and that is why there are special provisions to ensure protection of children. One such example I would take is the POXO Act, which seeks to create a special criminal legislation for the protection of children by coding all the offenses against children and ensuring that the perpetrators are met with a higher punishment. Hence, under Article 15, subclause 3, various legislations have been enacted, be it the Domestic Violence Protection Act, be it the Prevention of Sexual Harassment at Workplace Act, to ensure that women and children are protected by law, and special provisions are made to ensure gender parity. Not only does this fulfill India's obligations as a welfare nation, but also India's international obligations under various treaties, including the CEDAW, which is a convention that ensures that equal opportunity and gender justice is accessible to all women. Women and children also face the dual challenge of not only being discriminated based on gender, but also on the basis of caste and religion. Therefore, it is necessary to have such positive affirmation measures to ensure that they have special access to equal opportunities. Article 15, subclause 4, was introduced by the First Amendment to the Constitution of India, and it recognizes the historic discrimination carried out against certain castes, and therefore it seeks to provide reservation in the form of to the Article 15.4 seeks to provide reservation to the educationally backward classes of citizens as well as the scheduled castes and scheduled tribes. It is only recently that we have a special legislation which ensures equal protection to the scheduled castes and scheduled tribes, and in fact, there's a special legislation which criminalizes offenses against the scheduled castes. This leads us to a very important aspect of our history, that we see that since so many years of independence, what was seen as an initial measure required to bring about an end to discrimination, as a nation we have failed to do so. And despite various attempts to bring about an end to reservation, gradually we see that we have not been able to achieve our goals towards the welfare nation and towards upliftment of all sections of society, which is what has been realized by the legislation. And in 2018, there was another amendment to the Constitution. This amendment was introduced by the Minister of Social Justice and Empowerment, and this was passed by the Lok Sabha as well as the Rajya Sabha in 2019, whereby Article 15.5 was introduced to the Constitution. This particular provision of the Constitution ensures reservation in educational institutions, including private educational institutions, whether they are aided or unaided by the state, other than minority institutions referred to in Clause 30, Subclause 1 of Article 30. Under Article 30, Subclause 1, minority institutions had a special status since the inception. However, over time, it has been realized that education is a tool of empowerment, and it is necessary to bring about equal opportunity in the educational sector, whether be it at the schools or be it in the graduation or post-graduation courses. That is why we see this special legislation being enacted to ensure that equal opportunity in education is granted not only in private schools and government schools, but across all institutions uniformly. Because though various measures have been taken by governments and state legislatures in their independent capacities to ensure equality to everyone, and especially to the economically backward sections of the society, unfortunately, it so happens that those schemes exist, people do not have an access to it. Hence, Article 15, Subclause 5 has been brought about to ensure a wider reach to all sections of society when it comes to educational opportunities. The importance of education has been recognized not just in the fundamental rights in the Constitution, but also in the directive principles of state. In fact, Article 21A ensures that right to education is a fundamental right, and we can easily interpret Article 15, Subclause 5 in furtherance of Article 21A. Because a fundamental right by itself would lose teeth if there is nothing to ensure its enforceability. With this, let us go through some case laws which highlight various aspects of interpretation of Article 15 through judicial proceedings. One such case is D.P. Joshi versus State of Madhya Bharat. This particular case is very important because it shows the fundamental nuances when it comes to interpretation of the phrase origin by birth and domicile. It differentiates between domicile and place of birth Article 15, subclause 1 ensures that nobody is discriminated by way of place of birth. However, it was held by the Supreme Court in this particular case that just because one is protected by Article 15, subclause 1 when it comes to the place of birth, it is not necessary that the rule of domicile should also be scrapped in light of discrimination in Article 15.1. In this particular case, it was alleged that there is a discrimination when capitation fee is charged for people residing beyond Madhya Bharat or Madhya Pradesh as it was then known. It was held by the Supreme Court that it was held by the Supreme Court that this particular rule of the institute is not discriminatory but actually seeks to create an intelligible differential between people residing in Madhya Bharat through a transfer in their domicile and people who are born in Madhya Bharat. Therefore, this rule was upheld by the Supreme Court. In the case of Air India versus Nargesh Minja, we see the Supreme Court struck down Regulation 46 and 47 of the Air India and Indian Airlines, whereby this was a sexist law which was brought about to impose conditions on air hostesses who would have to resign either because of their marriage or pregnancy or having hit the age of 35 years. This was held to be contrary to Article 15.1 as well as Article 15.3. And it was held that in such a situation, such a law which discriminates against women by denying them their fundamental choices in life cannot be held to be such a law which recognizes that, such a law which discriminates against women by disallowing their fundamental choice to have an employment or to have their life choices is contrary to Article 15 of the Indian Constitution. This also fulfills India's obligations towards gender parity and ensuring equal right to work and freedom under Article 19(1)(g). In the case of M.R. Balaji versus State of Mysore, it was held that reservation of up to 68% for backward classes was held to be contrary to Article 15, subclause 4. Article 15.4 did not allow for a separate segregation in backward classes, and over here the state was flawed in making a policy whereby they had brought about reservation for ST/SCs as well as a separate reservation of 28% for other backward classes. In this particular case, the Supreme Court held that a reservation policy of 68% was contrary to Article 15, subclause 4, which only envisaged positive discrimination or affirmative action for backward classes, and it did not seek to provide a separate segregation within the backward classes. Hence, a policy whereby there was reservation of 22% and an additional reservation of 28% for backward classes was contrary to the Constitution. This brings us to the most important aspect of reservations when it comes to right to education and Article 15. The first case that we would discuss in this is TMA Pai Foundation versus State of Karnataka. This particular case held that reservation in unaided private institutions was contrary to Article 19(1)(g) of the institutions, which is the right to practice profession. This led to the government enacting the 93rd Amendment to the Constitution and the formulation of a special legislation for central institutions. The same was challenged in the case of Ashok Kumar Thakur versus Union of India unsuccessfully, and it was held that this particular legislation would be valid. But the question with respect to unaided private schools was not decided in Ashok Kumar Thakur's case, and it was left open for a larger bench, which was eventually decided in the case of Society for Unaided Private Schools for Rajasthan versus Union of India. Three aspects of this case are of importance. Firstly, it was held that Article 21A of the Constitution ensures everyone has the right to education, and keeping in mind this fundamental right, we cannot read the right of institutions in isolation to practice their profession and earn. Therefore, even private schools would be within the ambit of reservation, and the welfare of children is of primary importance. Therefore, keeping in mind the welfare of children as well as their right to education and to ensure social justice, it is important to have equal opportunity in educational institutions. With this, I conclude my lecture. Article 15 is a very wide legislation, and it encompasses various everyday lives, various aspects. Article 15 is a legislation that encompasses various aspects of everyday life of an individual, be it work, education, or equal opportunity when it comes to access to public places around you. Therefore, this particular legislation has seen frequent challenges and it has led to frequent litigation, and all aspects of Article 15 cannot be covered in one particular lecture. Therefore, in my next lecture, I shall be discussing about Article 15 when it comes to the profession and Article 15 when it comes to public sector undertakings. Thank you.